In continuation of our yesterday's lecture on Indian Penal Code, today what we'll do is we'll also give you a broad idea about what the syllabus of our UP-APO exam is all about. And apart from that, we'll also discuss the first topic in detail which we are going to discuss today is about the general exceptions. But before that, you have to keep in mind that in UP-APO, the Commission has categorically laid down as to what questions will be asked, what number of questions will be asked, and from which areas they are going to ask those questions. So before starting your preparation, you have to have a very confident and very strategic approach as far as your preparation is concerned. मतलब यूपी कमीशन ने जो है, उत्तर प्रदेश पब्लिक सर्विस कमीशन ने आपको अपने सिलेबस में ही कितने क्वेश्चन सब्जेक्ट वाइज पूछे जाएंगे इसका ब्रेकअप दिया हुआ है. एंड आप जब अपनी प्रिपरेशन कर रहे हो, स्ट्रेटेजिकली टाइम हैज टू बी डिवाइडेड कीपिंग इन व्यू what breakup of questions have been provided under the syllabus. Okay. So having said that, we'll see that in UP-APO, the syllabus for Assistant Prosecution Officer exam, there are 150 questions which are there. And in that 150 questions, the maximum time is 2 hours, and in 150 questions, 50 questions are on basically the general knowledge, and rest of the 100 questions are basically on the law subject. As far as the general knowledge area is concerned, the maximum weightage which is given is to the current affairs. You can easily see here that current events of national and international importance have a weightage of say around 10 questions. Then apart from that, the other areas which are there in the general knowledge, they have equal weightage. मतलब current events, national और international importance का यहाँ पे सबसे ज़्यादा क्वेश्चन पूछे जाते हैं, 10 questions. और अदर जो एरियाज हैं, साइंस हो गया, हिस्ट्री ऑफ इंडिया हो गया, then Indian national movement, specifically since history of India will also include Indian national movement, but they have also created a separate category of Indian national movement in which they are asking specifically 8 additional questions. So history of India, meaning thereby it will include not only ancient history but as well as medieval history. And apart from that, in modern India, separately 8 questions they will ask from the Indian national movement. So that is why the next weightage specifically goes to the history. So if you have a command over history, and if you have a command over the current affairs, around 8, 8, 16 and 10, 26 questions are directly there from these areas which are there. So before landing into any area which you are totally unaware, or before starting your preparation blindly, you have started studying geography and you are not even aware that in geography which area they are basically asking questions upon, what has been specifically given in the syllabus, what is the cost benefit that will be available to you when you are basically preparing geography. So in geography, you'll see they will in the syllabus it is mentioned as world geography and population. So they will ask questions on world geography, they'll ask questions on population. So you have to target world geography when you are studying basically the geography portion, the climate and so on, the world geography, the specific locations that are there. When we'll discuss GS and GK questions which have been asked on GS and GK, we'll focus on that area as well. Apart from that, Indian polity and economy, 8 questions have been listed here in Indian polity and economy. Polity, since you are a law student, obviously a broad idea about constitutional law you would be having. सो कॉन्स्टिट्यूशन लॉ आपको पता ही है, जब आप कॉन्स्टिट्यूशन लॉ पढ़ते हो। पॉलिटी में थोड़ा जो है गवर्नेंस, सिस्टम ऑफ गवर्नमेंट, पार्लियामेंट, प्रेसिडेंट, गवर्नर, ये सारी चीज़ों पे ज़्यादा फोकस किया जाता है। सो पॉलिटी you will not find much difficulty in preparing. So these are certain areas in which you can direct your preparation. इन areas पे focus करके आप अपनी preparation को direction दे सकते हैं। And आपका aim ये होना चाहिए कि कैसे अपने time को हम ऐसे utilize करें कि जिसमें हम ज़्यादा से ज़्यादा जो area है उसको cover कर सकें। So current affairs is definitely one of the most important area. Apart from current affairs, directly you can focus on the Indian national movement, the modern history. Then obviously ancient history and medieval history is there. But ancient and medieval history, ancient history you can easily cover. Medieval history, people generally tend to ignore that. But that is not advisable on our part. Obviously some broad ideas, some basic idea of the timelines you are definitely required to have. Okay. So here we see that 50 questions are there in the area of general knowledge. 8 5s are 40, and then 10 questions from current affairs, 50 questions. Now we come to the main part of this exam, which is the part 2 of the UPAPO paper, which consists of questions related to the legal subjects. In that, firstly, and the foremost important section is basically the Indian Penal Code. As you see that in the Indian Penal Code, the questions, number of questions that they are asking is the maximum, that is 35 questions. Indian Penal Code से सबसे ज़्यादा क्वेश्चन पूछते हैं 35 क्वेश्चन से. बट आपको ये भी समझना होगा कि obviously every aspirant do you have the competitive edge? Because if an easy question has been asked from the Indian Penal Code, अगर Indian Penal Code से कोई easy question पूछा जाता है, तो comparatively आपके जो competitors हैं, वो भी it is very much expected that they will also answer correctly. But when any tough questions has been there from this area, then obviously the level of your preparation will get determined. But broadly we see that all the serious aspirants, they have generally a good command over these subjects like Indian Penal Code, the Criminal Procedure Code, and the Indian Evidence Act. So if you are preparing for judiciary, already these subjects are common in the judicial services exam as well. But apart from that, what areas are there in which you can focus? So Indian Penal Code, Evidence Act और Criminal Procedure Code, ये judicial services के एग्जाम में भी पूछा जाता है. और जो candidates judicial services exam में appear होते हैं, generally they also appear in these type of exams like the APO exam and other legal services exam, like PSU and so on. So apart from having a good command over Indian Penal Code, you have to be very cautious that you do not commit silly mistakes in these areas which are there in the legal field. Because if you commit a silly mistake, if you have committed an error in a very simple question that had been asked from Indian Penal Code, then chances are very high that you will be at a competitive disadvantage. इसी तरह होता है कि धीरे धीरे जो है, जो मेरिट लिस्ट में जो लोग हैं और जो मेरिट लिस्ट में नहीं हैं, उनके बीच का जो गैप है वो धीरे धीरे बढ़ता रहता है, either due to the silly mistakes that they commit or the simple questions that had been asked in the exam, they were unable to answer that simple question. क्योंकि सिंपल क्वेश्चन मेमोरी बेस्ड, सेक्शन बेस्ड क्वेश्चन पूछा है और आप उसको नहीं बता पाए, और कंपैरेटिवली जो आपके एस्पिरेंट्स हैं उन्होंने वो क्वेश्चंस आपको बता लिए. On the other hand, there was a tough question. Neither you were able to answer that tough question, neither your competitors were able to answer that tough question. Many a times questions are also deleted. So your aim should not be targeted towards those tough questions, or your aim should not be targeted towards those areas which are disputed, those areas in which there is conflicting opinion. Rather, your aim should be that the straightforward questions that have been asked. By no means you should commit an error in marking that questions correctly. जनरल एक्सेप्शन से सीधा क्वेश्चन पूछ दिया, मिस्टेक ऑफ फैक्ट में, अब आप कंफ्यूज हो गए, सेक्शन 76 का था कि सेक्शन 77 का था, आपने गलत सेक्शन लगा दिया, सेक्शन 77 आपने लगा दिया 76 की जगह. So this is a silly mistake. This is a very, and also when you have a broader coverage of the syllabus, this mistakes happens very commonly. पढ़ते वक्त लगता है कि ये क्या है, मतलब ये तो easy है, तो पढ़ा हुआ है. But we have seen that students they very much often commit these errors, and finally they end up getting out of the merit list. Simple example I'll state how this happens. Suppose Suppose 5 questions have been asked in an exam. Now, since 5 questions have been asked in exam, 3 questions were very straightforward. 3 questions were very related to the section, related to the case law. They were related directly. They were direct questions. They were easy and simple questions. Once you have command over those subjects, you have in mind the relevant sections in the Indian Penal Code, you are able to answer these 3 questions. Okay? Very much. Then is a situation that one question is, say, above medium, and one question is tough. Now the point is that most of the students would be attempting these questions correctly. These 3 questions, most of the students who deserve to be in the merit list, they will attempt these 3 questions correctly. But what happens is that suppose this question, the question number 2, this was an easy question, and you also know that. भाई एग्जाम टाइम में सिनेरियो डिफरेंट होता है. घर पे आप आके वही क्वेश्चन सॉल्व करोगे, आपका नंबर 1-2 क्वेश्चन से अधिक हो जाएगा. So what did you do is that in these easy questions, the second question you marked incorrectly due to your, either you couldn't recall, or due to silly mistake, or due to hurriedness, you committed this question, you marked this question incorrectly. आपने ये क्वेश्चन गलत कर दिया. अब इस क्वेश्चन, ये जो है मेरिट लिस्ट में ऑलमोस्ट एवरी स्टूडेंट हैज बीन अटेम्प्टिंग ऑल दीज 3 क्वेश्चंस करेक्टली, लेकिन आप किसी लिए मिस्टेक की वजह से इसको आपने गलत मार्क कर दिया, लेकिन आपको ये क्वेश्चन पता था. घर पे आप आके बिना किताब देखे आपने इसको सही मार्क कर दिया. नाउ व्हाट हैपेंस इज, इन ऑर्डर टू कंपनसेट द लॉस विच यू हैव इनकर्ड ओवर हियर, you have to attempt any tougher question correctly, which are very likely chances that you might not end up getting that correctly. Or if you get, and if you have really command, you will fulfill it. From medium to tougher questions, अगर कोई easy question गलत हो गया, लेकिन फिर भी आपके सब्जेक्ट में कमांड अच्छी है, तो टफ क्वेश्चन और मीडियम टू टफ क्वेश्चंस के रेंज में जो क्वेश्चंस आते हैं, उससे आप वो लॉस जो है कवर कर सकते हो. लेकिन वहीं पे द मेरिट लिस्ट ऑल्सो डिपेंड्स अपॉन द नंबर ऑफ सीट्स विच आर देयर. सो इफ द नंबर ऑफ सीट्स इन एनी एग्जाम इज वेरी लेस, फॉर सपोज UPAPO, then obviously the scope of error that you can commit is also very less. क्योंकि वहां पे आपने एक ये गलती कर दी, और हो सकता है बाकी आपके कॉम्पिटिटर हैं उनकी भी कमांड अच्छी है, बिकॉज लेस स्टूडेंट्स विल बी सिलेक्टेड ना. सो व्हेन लेस स्टूडेंट्स विल बी सिलेक्टेड, देन यू विल सी दैट मोस्ट लाइकली द चांसेस आर दैट इफ सीट्स आर लेस, यू विल एंड अप paying heavily due to a silly mistake that you had committed. So that is why advice is there that in always you have to keep in mind that you have to target the straightforward questions, the simple questions. Your idea of preparation should not depend upon getting mastery over the subject in such a manner that whatever they will ask, you'll be able to answer. You have although the endeavor should be there, but as far as practicality is concerned, by achieving such a high objective in such a short duration, you should keep in mind कि ज़्यादा तेज बनने के चक्कर में simple क्वेश्चन भी आप जो है गलत करके ना आ जाइए. Okay. So this was a general broad idea about the syllabus of the UPAPO exam which is concerned. We see that the general knowledge questions are there. 50 questions are asked from general knowledge. Maximum time is basically 2 hours. And time you have sufficient. In 120 minutes, you have 150 questions around. So generally, by nature of the time and the number of the questions that have been asked, मतलब कितना time allotted है? 120 मिनट. और क्वेश्चन टोटल कितने हैं? यहां पे हो गया 100, यहां हो गया 50. 150 क्वेश्चन. Meaning thereby you cannot spend more than a minute on a single question. You have to spend less than that. 120 क्वेश्चन 120 मिनट में 150 क्वेश्चन करना है. हर क्वेश्चन को 1 मिनट भी नहीं दे सकते हैं प्रॉपरली. Because that is why the nature of the questions also depend. Most of the questions, they are straightforward. They are to the point. They will simply ask the section. They will simply ask, this case law is there, is related to which? They will simply ask you to match the following sections with the relevant keywords which are there. So most of the questions are straightforward. And it is expected, had the questions been so much elaborate, so much diverse, so much disputed, then this time limit which is there would have been impractical. So ये चीज ध्यान में रख के आपको जो है करना है. Just a second. Okay. Now we come to, so if you have any doubt with respect to the broad idea of the UPAPO exam, you can unmute yourself and ask. Okay. So ये clear हो गया. Now we'll come to our topic of discussion, which is basically the general exceptions. So yesterday, Rupesh sir has also taught you the broad idea about the index, some important sections he had also highlighted. So we'll go in tandem. We'll cover the syllabus comprehensively, and based upon what is required for this particular exam in this relevant duration of time, we are going to base our approach in teaching you in this course progression. We'll keep that in mind. Okay. So general exception, हमें पता है. Firstly, the question arises, in which chapter general exceptions is given? So general exceptions cover होता है chapter 4 में. Okay. Chapter 4 of the Indian Penal Code deals with the general exceptions. Just a second. So here on in the slide you can also see that chapter 4 of the Indian Penal Code, that is from section 76 to 106, deals with the topic of general exceptions. What is this general exceptions? Where the liability for any crime, what is the effect of this chapter upon that liability? So these are very important areas, chapter 4 of the Indian Penal Code, from section 76 to 106. And this is one of the most important areas in the Indian Penal Code in which frequently the question has been asked. And in this chapter, you will find that the scope of error is very less, because this is one of the core areas which is there in the Indian Penal Code. Almost every serious aspirant is very well aware of this chapter. Each and every section they can recall at their fingertips. So chapter 4 of the Indian Penal Code from section 76 to 106 deals with the topic of general exceptions. These general exceptions, they deal with the grounds on which the liability for any crime gets negatived. कोई भी liability है, उसके ऊपर general exceptions chapter का क्या effect होता है? So for that, firstly you have to refer section 6 of the Indian Penal Code. Okay. Section 6 of the Indian Penal Code, here you will see, simply states that throughout this code, every definition of an offense, every penal provision and every illustration of every such definition or penal provision shall be understood subject to the exceptions contained in chapter entitled General Exceptions. Meaning thereby the provisions which are there, which makes the act of any person criminally liable, is subject to the exceptional circumstances, is subject to the general exceptions which are given under chapter 4 titled General Exceptions. Okay, so this general exceptions, it negatively also gives force to the doctrine of mens rea. Many a times we see that due to many circumstances, either the mens rea is absent or the situation is such that the liability should be exempted, or the circumstances is such that any criminal act, even though it's an offense, due to certain circumstances, due to certain situation, due to certain scenario, it is generally treated as justified in law. So this entire chapter is also based on the maxim actus non facit reum nisi mensit rea. It negatively gives force to the doctrine of mens rea which is there. Okay. So section 6 we have understood, and the general liability is understood subject to the general exceptions which is given under chapter 4. And chapter 4 of the Indian Penal Code starts from section 76 and goes on until section 106. Apart from that, another provision which also is related, which also is connected with the general exception, is section 105 of the Indian Evidence Act. What do we understand by section 105 of the Indian Evidence Act? So for section 105, we must understand that generally in crime what is there? The burden of proving. Any accused who's there, he's generally treated as what? He's generally treated as, in criminal jurisprudence, he's generally treated as innocent, unless he has been proven guilty. Crime में accused को innocent presume किया जाता है, unless he has been proved guilty. And therefore, generally, in criminal law, the burden of proving that the person has committed a crime lies upon whom? Lies upon the prosecution. But if any scenario arises, and if that scenario is covered under general exceptions, then burden of proving that these circumstances exist or the benefit of the general exception can be claimed. So that the burden of proving that these circumstances exist wherein any of the general exceptions which have been given under chapter 4, they can be claimed. In that case, by virtue of section 105 of the Indian Evidence Act, if the accused is claiming such benefit of the general exception, then the burden of proving that these circumstances exist will lie upon the accused. मतलब सिंपल क्या है? जनरली भाई बर्डन ऑफ प्रूफ जो होता है प्रोसिक्यूशन के ऊपर होता है, लेकिन अगर कोई अक्यूज्ड है, accused was unable to know the nature and consequence of his act by reason of insanity or unsoundness of mind. This has been given under one of the circumstances. This has been exempted under section 84. Now the burden of proving that his act is covered under one of the general exception which is given under the chapter 4, then the burden of proving that this circumstance exists will lie upon the person who claims that this exists. मतलब accused जो कहेगा कि by such reason of insanity I was unable to know the nature and consequences of my act. Therefore my act, my criminal act should be exempted. That is why all these sections from section 76 to 106, almost every section which properly deals with the general exceptions, almost every section they start with the expression, or substantially they have this expression, nothing is an offense. मतलब offense हुआ ही नहीं. जो भी criminal liability है it is entirely negatived. Almost every section you see, they start with the expression, nothing is an offense. And what are the various circumstances? What are the broad outlines that we are going to discuss? Okay. So exceptions, in this sense we understand that exceptions can be conceptually, concept wise जो है exception को दो कैटेगरी में आप डाल सकते हो. एक्सक्यूजेबल हो सकता है और जस्टिफिएबल हो सकता है. एक्सक्यूजेबल meaning thereby law has treated certain classes of persons even though they had committed the offense. Law treats that they do not constitute the requisite criminal intent and their liability is therein negatived. Justifiable in those cases wherein the circumstances are such that even though if an act has been generally committed as considered as an offense, in the given particular circumstances it was justified. So conceptually जो है general exceptions को दो broad category में divide कर लेते हैं, excusable and justifiable. Excusable के example जैसे infancy हो गया, insanity हो गया, intoxication हो गया, mistake, accident, all these are under excusable category. Justifiable category में most importantly we have the right of private defense which is there. Then necessity is there. Offense committed under duress is there. Okay. Consent, trivial act, all these are generally justifiable. So having said that, now we'll draw a broad conceptual outline of the entire section. अब इसमें आपको इंपॉर्टेंट ये याद रखना है कि जनरल एक्सेप्शन में क्वेश्चंस जो हैं, क्वेश्चंस how they are asked, what is the content of the question. Firstly, you have to keep in mind the section number. One type of question they can ask is directly related to the section. Defense relating to intoxication is covered under which section? Defense relating to infancy is covered under which section? Defense relating to unsoundness of mind is covered under which section? Mistake of act, privileged act या judicial act बोल लो, एक्ट ऑफ अ जज, ये किस सेक्शन में आता है? सो वन टाइप ऑफ क्वेश्चन दे कॉमनली कैन आस्क इज डायरेक्टली रिलेटेड टू द सेक्शन. जनरल एक्सेप्शन कौन सा है, डिफेंस कौन सा है, और किस सेक्शन में है? Very limited sections are there. Easily it will hardly take you, it must, before exam, it must take hardly 1 or 2 minutes before you can quickly revise all the relevant sections which are there in the general exceptions. Because many a times we see that in the area of consent which is there, in the area of mistake of fact, Judicial Act, many a time since we are studying, we have a broad coverage of the syllabus, ज़्यादा सब्जेक्ट पढ़ने होते हैं, तो कभी कभी क्या होता है, कंफ्यूजन हो जाते हैं. सिंपल सिंपल सेक्शन में आदमी कंफ्यूज हो जाता है. कंसेंट के कौन से सेक्शन में है उसमें कंफ्यूज हो जाता है. 94 में क्या था, 95 में क्या था, इसमें कंफ्यूज हो गए. सो इंडेक्स से आपको एक बार जो है जनरल एक्सेप्शंस के सारे सेक्शन नंबर जो है, किस सेक्शन में कौन सा जनरल एक्सेप्शन कवर्ड है, ये आपको डेफिनेटली पता होना चाहिए. One type of question they can simply ask about the relevant section and what is there in that. Then the second type of very commonly asked question is illustration. Now sections are there, general exceptions are there. In that general exception, there are certain important illustrations. What they will do is that they will simply ask you about the illustration, and then they'll ask you that this illustration, what will happen in that illustration, whether the defense will be available or whether the defense will not be available. Simple question. So here you need not memorize anything. If you have conceptual clarity, easily you will able to answer that question. Secondly, अब illustration को थोड़ा और technical करके, given illustration is covered under which section? Now you get confused whether it was section 80 or whether it was section 81. So obviously those illustrations which are specifically given under specific statute, under the statute in the relevant provision, under which relevant provision that illustration has been used, you have to keep that in mind. Because conceptual question होगा तो easily आप कर लोगे. लेकिन apart from that, illustrations भी किस section से कौन सा illustration है, you can keep a keyword with respect to that. जैसे accident वाला जो है section 80, उसमें जो celebrated, very commonly used, and also it is given in the statute itself, is the illustration of man is working with a hatchet and the head flies off and kills any person who is there. So in that, this illustration is given under which section? If proper care and caution has been exercised by the person who was working with the hatchet, then under which section he can claim the defense from criminal liability? Under which section his criminal liability will get negatived? So इसमें सिंपल हाथ में ऑप्शन दिए रहेंगे 80, 81, 82, 83. अब आप कंफ्यूज हो गए. सेक्शन तो अच्छे से पता था, इलस्ट्रेशन नहीं पता था. लेकिन इसका भी है, ऑब्वियसली if you have a clarity, you will understand that no, it's definitely he has exercised due care and caution, and it's an accident that has happened. Therefore, section 80 will be the correct. So this type of questions. And thirdly, most common type of questions they'll ask from general exception is with respect to the case laws. Case laws हो गया, लीडिंग केस लॉज. हर टॉपिक में इंपॉर्टेंट लीडिंग केस लॉ कौन सा है? मिस्टेक ऑफ फैक्ट, आर वर्सेस टॉल्सन. So these type of questions they are going to ask, and you have to focus on that only. Sections and verbatim of that section you have to prepare. So this is one of the area in the Indian Penal Code wherein you are required to also remember the ingredients which are there in the section. सेक्शन नंबर हो गया, उसके अंदर के इंग्रेडिएंट्स क्या हैं उसे भी दिमाग में रखना है. देन उसमें जो इलस्ट्रेशंस हैं वो क्या है, एंड देन व्हाट इज द आउटकम ऑफ दैट इलस्ट्रेशन. दैट इलस्ट्रेशन इज गिवन अंडर विच सेक्शन. And then lastly, important leading case laws on that defense. And that, if you have paid attention to these three things, fairly you will be able to answer almost all the questions. Okay. So, broad outline of general exceptions, if you are going to draw. General exceptions, it can be divided in two categories: absence of criminal intent or knowledge, and then there is presence of criminal intent or knowledge. Now the absence of criminal intent or knowledge can be further categorized. There is privileged act, then there is act in which there is absence of will, then there is will act done where the will is not directed to the deed. Then will overborne by necessity, or compelled by threats. Then you have consent. Then finally you have right of private defense. So these general exceptions, we can conceptually categorize them under separate heads for the convenience of remembering them and so on. Firstly, we have privileged act, or commonly it has been categorized as judicial acts. So act of a judge is also protected when that judge is acting judicially. That is also protected. And any person in pursuant to the judgment or under the warrant of such judgment which is in force, that is also given a protection. In which section these are covered? Firstly, separate sections are there. Act of judge, when the judge himself through his judgment has, now the question arises, when the judge pronounces a judgment, will that be an offense? Is there any defense which is available to a judge when acting judicially he has done some act? So for that we have section 77. Then secondly we have act done pursuant to judgment. Pursuant to judgment. Here we have section 78. So these two categories are of privileged act. Section 77 and section 78. Section 77 deals with the act of a judge himself. Section 78 deals with act of any other person. He's not a judge, and he has acted in pursuance of any judgment of a court of justice. Then his act is protected under section 78 if that judgment is in force. इस पे एक बहुत कॉमन एग्जाम्पल सेक्शन 78 पे जो है वो पूछता है आपको, बताइए कौन सा कॉमन एग्जाम्पल पूछता है, कौन सा क्वेश्चन आता है इस पे, बताओ रक्षा। यस, हैंगमैन। बताता हूं मैं आपको, जैसे इस टाइप के डायरेक्ट क्वेश्चन आता है, अ हैंगमैन हु हैंग्स द प्रिजनर्स pursuant to the order of the court is exempt from criminal liability by virtue of, मतलब एक हैंगमैन जो है, जो प्रिजनर को हैंग करता है, pursuant to the direction or order or judgment of a court of justice is protected under which section? ऑप्शन में है 77, 78, 79, 76। यहीं पे आप कंफ्यूज हो गए, 78 था कि 79? सिंपल क्वेश्चन, डायरेक्टली द आंसर शुड बी सेक्शन 78 ऑफ द इंडियन पिनल कोड. Then we come to the those category wherein there is absence of will. It can be divided into three parts: infancy, insanity, and intoxication. Infancy has been covered under section 82 and 83. Insanity has been covered under section 84. Intoxication has been covered under section 85 and 86. स्टार्टिंग जो है उसको याद करने का तरीका मैं बता रहा हूं. विल नॉट डायरेक्टेड टू द डीड, इसको बताने के बाद मैं बताऊंगा. ओके, हियर ऑल्सो इट कैन बी divided into three categories: mistake of fact, then you have accident, and then finally you have act or communication in good faith. So will not directed towards any deed. Here you have mistake of fact, section 76 and section 79. Then accident is there under section 80. Act or act done in good faith without the consent, communication made in good faith, here also is there. Act done in good faith is covered under section 92. Communication made in good faith is covered under section 93. Will overborne by necessity, it's covered under section 81. Or will wherein an act is committed by any person who has been compelled by threats, this has been covered under section 94. Consent has been covered under section 87 to 91. And then you have right of private defense under section 96 to 106. So this is the broad categorization and the broad outlay of the sections which are there. Quickly we'll see how it has been laid down. Okay, so firstly you have mistake of fact. Section 76 हो गया and section 79 हो गया. Act done by a person bound by law to do it, or if by mistake of fact he believes himself bound by law to do it in good faith. यहां भी एक mistake of fact आया. Section 79 इससे मिलता जुलता है. यहां आप देखिए section 76 and section 79. Section 76 deals with act done by a person who is bound by law, to do it, or by mistake of fact believes himself to be bound by law to do it in good faith. This has been covered under section 76. Section 79 also deals with mistake of fact. Act done by a person justified by law to do it, or by mistake of fact believes himself justified by law. So यहां पे आपका यहां भी मिस्टेक ऑफ फैक्ट है, बस डिफरेंस इसमें ये है सेक्शन 76 और सेक्शन 79 में. सेक्शन 76 डील्स विद लीगल कंपल्शन, because the person is bound by law, or either by mistake of fact he believes himself bound by law to do that. So there is an element of legal compulsion under section 76. Mistake of fact is there in section 76 also, mistake of fact is there in section 79 also. Section 79 on the other hand deals with legal justification. Here compulsion element is not there. Here also mistake of fact element might be there. A person is justified, or by mistake of fact he believes himself justified by law in doing any act. So examples and illustrations of that we'll study. But before that, currently what we are doing is, currently we are understanding the broad outline of the sections which are there in general exception. So section 76 और section 79 ये किससे डील करता है? मिस्टेक ऑफ फैक्ट से. सेक्शन 76 में ऐसा मिस्टेक ऑफ फैक्ट जो कोई पर्सन अपने आप को in good faith he believed himself bound by law to do it. So his act would then be exempted, because section 76 starts with the expression what? Nothing is an offense. So एक type of mistake of fact आपका section 76 में cover होता है, और next mistake of fact where the person by mistake of fact believes himself justified by law in doing that thing in good faith. Then another kind of mistake of fact is covered under section 79. So starting जो होता है section 76 और दो section छोड़ के section 79, it deals with mistake of fact. बीच के दो section रह गए, section 77 and section 78. It deals with judicial acts. Judicial acts मतलब जो privileged act होते हैं. Act of a judge किसमें covered होता है? section 77 में. इसी से related next section इसी से related है. सेक्शन 77 में जज को प्रोटेक्शन मिलती है. सेक्शन 78 में एनी पर्सन हु इज एग्जीक्यूटिंग एनी जजमेंट ऑफ अ कोर्ट ऑफ जस्टिस व्हाइल द जजमेंट इज इन फोर्स एंड ही बिलीव्स दैट द कोर्ट हैज द जुरिसडिक्शन, इन गुड फेथ he has executed the judgment, then his action is also protected under section 78. बहुत कॉमन क्वेश्चन इसमें आता है हैंगमैन का. जज ने अगर कोई जजमेंट सुना दिया that the person should be executed, then act of a judge when acting judicially, his action is also protected, and the person who executed the judgment, the person who put any person to sentence, his action is also prevented under section 78. So ये हो गया पहला आपका स्टार्टिंग होगा मिस्टेक ऑफ फैक्ट से 76 एंड 79, एंड देन बीच वाले दो सेक्शन जो है वो प्रिविलेज्ड एक्ट है, जुडिशियल एक्ट्स हैं 77 एंड 78. तो अब हम लोग कहां तक पहुंच गए? 76 से 79 वी हैव कवर्ड. नेक्स्ट सेक्शन आ गया सेक्शन 80. सेक्शन 80 किससे डील करता है? एक्सीडेंट से. एक्सीडेंट इन डूइंग अ लॉफुल एक्ट. नेक्स्ट सेक्शन एक्सीडेंट के बाद नेसेसिटी आ जाता है. एक्ट लाइकली टू कॉज हार्म बट डन विदाउट क्रिमिनल इंटेंट एंड टू प्रिवेंट सम अदर हार्म. एक्सीडेंट आ गया तो पहले स्टार्टिंग हुआ था मिस्टेक ऑफ फैक्ट, फिर जुडिशियल एक्ट. जुडिशियल एक्ट बीच वाले दो सेक्शन है, 79 तक हो गया. 79 के बाद आप आ जाओ 80 पे। 80 है एक्सीडेंट, 81 है नेसेसिटी, act likely to cause harm but done without criminal intent to prevent other harm. It deals with the defense of necessity. मतलब हमें पता है कि हम जो एक्ट करेंगे उससे एक हार्म कॉज होगा, लेकिन जो हम एक्ट कर रहे हैं वो किसी क्रिमिनल इंटेंशन से किया हुआ एक्ट नहीं है, ये किसी और हार्म को प्रिवेंट करने के लिए ये एक्ट किया गया था। डिफेंस ऑफ नेसेसिटी, section 81. Okay, then we have infancy. 82 and 83 deals with the defense of insanity, infancy. Infancy मतलब below the age of sufficient degree of understanding. इसमें 82 deals with absolute immunity. If a person is below 7 years of age, he is absolutely immune. And if a person is, so this is absolute immunity is given under section 82. 83 में qualified immunity है। दोनों section infancy से relate करते हैं। Both these section deals with infancy. 82 में absolutely a person the liability is negatived. But under section 83 जब age 7 से ऊपर हो और 12 से नीचे हो तब वहां पे the degree of understanding can be examined. Whether the person who has committed the offense understood the nature and consequences of his act or not. अगर उसको समझ में आ रहा था कि हम जो एक्ट कर रहे हैं वो गलत है, then section 83 will not come into his protection. His liability will not be negatived under general exception. So section 83 distinguishes, it treats a person above 7 years and below 12 years as capable of committing an offense. But also, it gives also the exception if the person falls within this age category and it can be seen, it can be proved from the facts of the case, it can be ascertained that he didn't understand the nature and consequences of his act, even though he is above 7 years and below 12 years, then his liability will be exempted. Okay. So section 82 and 83 deals with the defense of infancy. Okay. ये हो गया infancy. Then section 84, very important, deals with the defense of insanity. Insanity defense: by reason of unsoundness of mind, a person is unable to understand the nature and consequences of his act, then the defense of insanity will be available to him. Then his act will be considered under the expression nothing is an offense. अगर अनसाउंडनेस ऑफ माइंड की वजह से कोई ऐसा एक्ट किया कि ड्यू टू सच अनसाउंडनेस द पर्सन वॉज अनेबल टू अंडरस्टैंड द नेचर ऑफ हिज एक्ट और वॉट ही डिड वॉज आइदर रॉन्ग और कॉन्ट्ररी टू द लॉ, then you have then his act will not be considered as an offense. Okay, so section 84 deals with the defense of insanity. Then section 85 and 86 deals with the defense of intoxication. आपने पढ़ा ही होगा इंटॉक्सिकेशन में। ऐसा तो है नहीं कि कोई पी ले, खुद से वॉलंटरली पी ले और जाके कोई क्राइम कमिट कर दे तो उसे डिफेंस मिल जाती है। However, if with against his will he has been intoxicated, involuntarily he has been intoxicated against his will, then due to such intoxication, if he was unable to understand the nature and consequences of his act, then also his liability will be negatived. So section 85 and 86. 85 and 86 deals with both the voluntary and the involuntary intoxication. Then you have 87 to section 90, or you can say 90 deals with the consent portion. Consent. Act not intended 87. अब यहाँ पे थोड़ी confusion हो जाती है. So यहाँ पे आपको जो 87 to 90, 90 तो खैर conceptual है. 87, 88, 89, 91 and 92. Here you have to remember the sections keeping in view the illustrations which are there in that sections. Then you will not forget about what the sections which are there. Section 87, act not intended and not known to be likely to cause death or grievous hurt done by consent. Wrestling वाला example, voluntary not fit injury. Act not intended to cause death done by consent in good faith for person's benefit. Act जो है was not intended to cause death, and that act was done by consent in good faith for the person's benefit. जैसे अगर आप कोई सर्जरी कराने जाते हो तो आप कंसेंट देते हो, ये यहाँ पे ये वाला इलस्ट्रेशन आएगा. इसी का कोरोलरी है एक्ट डन इन गुड फेथ फॉर द बेनिफिट ऑफ द चाइल्ड और इनसेन पर्सन बाय द कंसेंट ऑफ द गार्जियन. सो 87 हो गया वॉलंटरी नॉन फिट इंजूरिया वाला, 88 हो गया सर्जन वाला एग्जाम्पल, और 89 हो गया कोई चाइल्ड है या इनसेन पर्सन है तो उसके कॉन्टेक्स्ट में द गार्जियन और द पर्सन हु इज इंटाइटल्ड he can consent for his benefit for an act to be done in his good faith. So 89 deals with that. Then what is the meaning of the consent given under this code? What do you understand by the general overview of consent has been provided under section 90. Section 91, exclusion of acts which are offenses independently of the harm caused. Meaning thereby, if you have consented to an act and otherwise that act is itself an offense, then the liability will not be negatived. Just like in the case of miscarriage. Miscarriage अलग से punishable है, तो consent दे देने से your liability will not get negatived. Exclusion of acts which are offenses independently of the harm caused. Then act done in good faith for benefit of person with consent. So here act is done in good faith even without the consent of the person. That is also protected under section 92. Similarly, communication made in good faith under 93. Act done in good faith, 92, without the consent. 93, communication made in good faith. Then we have section 94. Act to which a person is compelled by threats. Act done under duress, where a person is compelled by threats, is provided under section 94. And lastly, we have the trivial acts. Act causing slight harm, or the trivial act which is covered under section 95. So this is the broad outline. Quickly we'll revise each and every section. 76 we understand mistake of fact, and section 79 is also mistake of fact. 76 deals with mistake of fact where a person is bound by law or believes himself to be so. Section 79 deals with also the mistake of fact where a person is justified by law. Mistake of fact के section 76 और 79 हो गया. 77 and 78 हो गया आपका act of a judge or act of a person acting pursuant to a judgment. Then 80 next section 76 to 79 हो गया. 80 क्या है? Accident है. 81 क्या है? Necessity है. 82 और 83 क्या है? Infancy है. Then 84 क्या है? Insanity है. So 80 आपको याद हो गया, एक्सीडेंट है. 81 नेसेसिटी है. 82 83 एक साथ आपका आता है इन्फेंसी में. Then 84 you already know, very popular section, deals with the defense of insanity, section 84. After insanity, immediately you have intoxication. So infancy, insanity, intoxication, तीनों आई लाइन से लगे हुए हैं. Infancy 82, 83, insanity 84, intoxication 85, 86. So 82 से 86 हो गया, 85 और 86 आपका intoxication. Then 87, 88, 89 कंसेंट से रिलेटेड है. पहला वाला रेसलिंग वाला, वॉलंटी नॉट फिंड इंजूरिया 87. 88 सर्जन वाला, मैंने कंसेंट दे दी, मेरा ऑपरेशन कर दो 88. 89 मैंने अपने बच्चे के लिए कंसेंट दे दी, उसका ऑपरेशन कर दो, सर्जरी के लिए 89 हो गया. 90 कंसेंट क्या होता है. 91 एक्सक्लूजन ऑफ एक्ट्स विच आर इंडिपेंडेंटली द हार्म, मिसकैरेज वाला एग्जाम्पल 91. 92 और 93 मिलते जुलते हैं. एक्ट डन इन गुड फेथ विदाउट द कंसेंट, कम्युनिकेशन मेड इन गुड फेथ 93. एक्ट हो गया 92, कम्युनिकेशन हो गया 93, दोनों गुड फेथ में किया हुआ है. देन यू हैव लास्टली एक्ट विच अ पर्सन इज कंपेल्ड बाय थ्रेट, ड्यूरेस में किया हुआ एक्ट, उसके रिगार्डिंग क्या है कंडीशन कि आपको सेक्शन 94 का डिफेंस मिलेगा. विल रीड दैट. एंड देन ट्रिवियल एक्ट, section 95. So having covered this, I think now you'll be able to at least remember section 76 to 95. Very easy. Everyone remembers it. There is no scope of error. 87, 88, 89 में कंफ्यूज मत हो जाना. कोई स्कोप नहीं है यहाँ पे एरर कमिट करने का. यहां एरर कमिट किया तो गए. ओके So firstly we'll start with the mistake of fact. Mistake of fact section 76 में क्या कहता है. Nothing is an offense which is done by a person who is or by reason of mistake of fact and not by reason of mistake of law in good faith believes himself to be bound by law to do it. मतलब वो ऑफेंस हुआ ही नहीं जो किसी आदमी ने किया ऐसा एक्ट जो वो सोच रहा था गुड फेथ में कि दैट ही इज बाउंड बाय लॉ टू डू दैट एक्ट. नथिंग इज एन ऑफेंस which is done by a person who is or who by reason of mistake of fact and not by reason of mistake of law in good faith believes himself to be bound by law to do it. Okay, इसमें दो इंपॉर्टेंट एग्जाम्पल है. एक सोल्जर को उसके सुपीरियर ऑफिसर ने कमांड किया. नाउ द सोल्जर इज बाउंड बाय लॉ to follow the lawful command of his superior officer to fire, to control a mob, to fire on the mob in order to control it. So here the soldier who is there, who is following the command of his superior officer, and the command is a lawful command, then he is bound by law to follow that command. And even if by mistake of fact he believes himself to be bound by law, then also his liability is exempted. Similarly, A, an officer of the court of justice, being ordered by that court to arrest Y. अब यहां पे ये तो हो गया directly he is bound. यहां mistake of fact and not by reason of mistake of law. Mistake of fact is exempted, not the mistake of law is exempted. Ignorantia facti excusat, ignorantia legis neminem excusat, ignorantia juris non excusat. Ignorance of fact is excused. Ignorance of law is no excuse. Okay. So here we see the other illustration was there is A, an officer of a court of justice, being ordered by the court to arrest Y. A जो है एक कोर्ट का ऑफिसर था, कोर्ट ने उसको ऑर्डर किया कि वाई को अरेस्ट करके ले आओ. नाउ ही इज एक्सरसाइजिंग गुड फेथ आफ्टर ड्यू इंक्वायरी. गुड फेथ कहां मेंशन्ड है? 52 में, प्रॉपर केयर एंड कॉशन. सो आफ्टर ड्यू इंक्वायरी अरेस्ट करने के लिए किसको बोला गया था? वाई को. उसने गुड फेथ एक्सरसाइज किया, लेकिन मिस्टेक ऑफ फैक्ट हो गई. वाई की जगह ही हैड अरेस्टेड जी. आफ्टर ड्यू इंक्वायरी बिलीविंग जी टू बी वाई, he arrests Z. Has the officer of the court, that is A, committed any offense? Answer is no. Under which section? Under section 76. कौन से illustration में दिया है? Section 76 के illustration में. Okay. So this is there. Now what is the difference with section 79? Here you have the same elements, just bound is replaced by justified. Act done by a person justified or by mistake of fact believing himself justified by law. Same thing is there. Nothing is an offense which is done by any person who is justified by law or who by reason of mistake of fact and not by reason of mistake of law in good faith believes himself to be justified by law in doing it. बताओ इसमें कौन सा इलस्ट्रेशन था? हर इलस्ट्रेशन के कीवर्ड पता होने चाहिए. जैसे 76 में क्या है? सोल्जर का फायरिंग करना अपने सुपीरियर ऑफिसर के कमांड पे. दूसरा इलस्ट्रेशन क्या है? कोर्ट के ऑर्डर में वाई को अरेस्ट करना था, कोर्ट ऑफिसर ने जी को अरेस्ट कर दिया. अरेस्टिंग जी इन प्लेस ऑफ वाई. एक लाइन में आपको ये इलस्ट्रेशन सेक्शन 76 में याद होना चाहिए. बताओ 79 में कौन सा इलस्ट्रेशन है? रक्षा, महिमा. Section 79 simply deals with the illustration wherein a person who was there, it appeared to a person that he has committed any offense. And by reason of the law which is there, which empowers him to apprehend that person, अगर मुझे लग रहा है कि अगला कोई ऑफेंस कर रहा है, सीआरपीसी में सेक्शन 43 में मुझे पावर दी हुई है कि उसका अरेस्ट कॉज करके नियरेस्ट पुलिस स्टेशन में आई कैन एप्रीहेंड हिम एंड आई कैन ब्रिंग हिम टू द नियरेस्ट पुलिस स्टेशन. So I was under mistake of fact that he is committing any offense. In reality, that was not there. In reality, what was there, that person was exercising his right of private defense. But when I saw, mistakenly I thought, by mistake of fact, I thought that this person is committing any offense, and I have by law the power to apprehend him, to arrest him, and to bring him to nearest police station. So even though I have committed this act, I was justified in doing it. And even if in this case there was a mistake of fact, then also I am justified. My act will not be an offense. Mistake of fact, wrongly caught innocent person. Very good. Okay. So the illustration under section 79 says that A sees Z commit what appears to be to A to be a murder. A ने देखा Z को कि Z क्या कर रहा है. A को ये लग रहा है कि Z जो है मर्डर कमिट कर रहा है. A sees Z commit what appears to A to be a murder. Now A, in the exercise of the best of his judgment, exerted in good faith of the power which the law gives to all person of apprehending murderers. अब A इसी पावर को एक्सरसाइज करके गुड फेथ में, कौन सी पावर? जो लॉ देती है टू अप्रीहेंड द मर्डरर्स, seizes Z and brings him into the authority, before the authorities. Has he committed any offense? Answer is no. Okay. However, it turned out later on that A was not committing any offense. Rather, he was acting in self-defense. Okay. So this is there. So mistake of fact हो गया. 76 deals with legal compulsion. 79 deals with legal justification. Mistake of fact is excusable, not the mistake of law. And good faith is also very important in the defense of mistake of fact. इसमें important cases आपको पता होंगे. R versus Prince. R versus Prince में mistake of fact defense नहीं दिया गया था because act was malum in se. Act was so much wrong in itself. It was so much revolting to the moral sentiments of the people. It cannot be allowed. R versus Prince में नहीं दिया गया था. इसमें आपको पता ही होगा फैक्ट. R versus Prince में क्या था? 18 ईयर से लेस थी जो गर्ल लेडी है, उसके रिस्पेक्ट में किडनैपिंग का चार्ज था. ओके. But he didn't knew. He claimed that I didn't knew that she was below the age of 18 years. Then R versus Tolson. R versus Tolson भी very important case है. Leading case, everyone knows. It's on the fingertips. बाइगैमी से रिलेटेड जो केस था, R versus Tolson. इसमें क्या हुआ था? 7 years का टाइम होता है when the person is presumed to be dead. And wife in good faith believed that her husband is dead. And during the tenure of 7 years, in such good faith, she had married some other person. It turned out later on that immediately after this marriage, the deserted husband, he reappeared. Now the question arises whether the girl should be liable for bigamy or not. Then the defense of mistake of fact was allowed in this case. In good faith, the wife believed that her husband is no more. Therefore, the mistake of fact defense was made available to her. R versus Prince, R versus Tolson, Chiranji versus State. Chiranji versus State is also relevant example. Chiranji versus State में क्या हुआ था? The person was there. He mistook his son for a tiger and he attacked him with axe. Okay, so this was there. Here we will see. ये मैंने आपको बता दिया. Appellant, under the influence of delusion due to defect in vision, assailed his son with an axe, considering that his son was a tiger, a dangerous animal, and not a human being, and that he was justified in doing so. It was held that the accused was protected under section 79. The case of Chiranji versus State. So illustration हमने कर लिया, section number कर लिया, case law आप कर लो. ये सारे case law जो है उसी पे हैं. Mistake of fact versus mistake of law. State of Maharashtra, M.H. George versus State of Maharashtra. Chiranji versus the state. Haji Mahmud Khan, Daulat Khan versus Emperor. R versus Prince, R versus Tolson. All these case laws are related to the mistake of fact. Okay. Then we come to section 77 and section 78. Act of a judge when acting judicially. Nothing is an offense which is done by a judge when acting judicially in the exercise of any power which is or which in good faith he believes to be given to him by law. Nothing is an offense. क्या? Nothing is an offense which is done by a judge, जो जज ने किया हो. Any time? No. When he is acting judicially in the exercise of any power which is vested in him, or which in good faith he believes to be given to him by the law. So, act of a judge is protected by virtue of section 77. Similarly, act done pursuant to the judgment or order of the court. Here also we'll see act is done in pursuance or warranted by what? Any judgment or order, while such judgment or order remains in force. Okay? Even if there is no jurisdiction. Even if no jurisdiction. Provided there is good faith. So this is all about section 78. It says that nothing which is done in pursuance of or which is warranted by, in pursuance of or it's warranted by what? Judgment or order of the court of justice, if done while such judgment or order remained in force, is an offense notwithstanding the court may have no jurisdiction. मतलब कोई भी ऐसा एक्ट जो किसी जजमेंट या किसी ऑर्डर के परजुएंस में किया गया हो, while that judgment or order was in force, will be an offense even if that court did not had jurisdiction to pass that order or judgment. But the person who has done an act in pursuance of such or in warrant of such judgment or order must in good faith believe that the relevant court had the jurisdiction. मतलब समझे? By law, even if the court did not had the jurisdiction, the person will not be held liable for an act done in pursuance of the judgment, provided mala fideli this cannot be given into effect. In good faith, any person who is executing, who is pursuing the judgment, in good faith he must believe that the court definitely had the jurisdiction. If the person is aware and mala fideli he pursues the judgment, then this defense is not available. Okay. So this is about the privileged acts. Now we come to the accident. Judicial acts we have done. If a judge does an act in the exercise of power given by law, which in good faith he believes to be, then he will not be held liable. Act done by virtue of judgment or order of the court, that we had done. Now we come to the accident. Accident simply has been dealt under section 80. It says that nothing is an offense which is done by accident or misfortune or without any criminal intention or knowledge in the doing of an lawful act in a lawful manner by lawful means and with proper care and caution. मतलब कोई भी ऐसा एक्ट जो एक्सीडेंट और मिसफॉर्च्यून से हो गया हो, लेकिन वो एक्ट जो एक्सीडेंट और मिसफॉर्च्यून से हुआ वो क्रिमिनल इंटेंशन के साथ नहीं किया गया था, क्रिमिनल नॉलेज के साथ नहीं किया गया था, और वो एक्ट जो है लॉफुल एक्ट था, जो लॉफुल तरीके से किया गया, लॉफुल मैनर से और बाय लॉफुल मीन से किया गया, एंड इट हैज ऑल्सो बीन डन विद प्रॉपर केयर एंड कॉशन, then the defense of section 80 will be available to him. It will not be an offense. Nothing is an offense which is done by accident or misfortune without criminal intention or knowledge, in the doing of a lawful act in a lawful manner by lawful means and with proper care and caution. इसमें मैंने आपको बताया, इलस्ट्रेशन इसका याद रखिएगा, हैचेट वाला एग्जाम्पल. A is at work with a hatchet. अभी इसमें आपको बताएंगे, एग्जाम में ये क्वेश्चन आया था और काफी लोग कंफ्यूज हो गए थे. A is at work with a hatchet, the head flies off and kills a man who is standing thereby. Here, अब ये here you cannot ascertain whether proper care and caution is present or not. क्योंकि एक्सीडेंट का अगर हम देखें तो इसके एसेंशियल क्या निकल के आते हैं, सेक्शन 80 में एसेंशियल्स जो निकल के आ रहे हैं वो ये हैं कि फर्स्टली द एक्ट इज डन बाय एक्सीडेंट और मिसफॉर्च्यून, इट वाज डन विदाउट क्रिमिनल इंटेंशन और नॉलेज, इट वाज डन व्हाइल डूइंग अ लॉफुल एक्ट इन अ लॉफुल मैनर बाय लॉफुल मीन्स. सो लॉफुल एक्ट हो गया, लॉफुल मैनर हो गया, लॉफुल मीन्स हो गया, तीनों चीज. एंड थर्डली प्रॉपर केयर एंड कॉशन. सो ये सारी चीजें जब प्रेजेंट होती हैं, देन यू हैव द डिफेंस ऑफ एक्सीडेंट दैट इज अवेलेबल टू यू. ओके. However, in this illustration, if you will see, A is at work with a hatchet, the head flies off and kills a man who is standing thereby. If the statement is until here only, then you cannot ascertain whether proper care and caution was exercised by that man or not. If he is working with a hatchet at a place where people are playing, where children are playing, then obviously it was an act which was not done with proper care and caution. Then the defense of accident will not be available. Similarly, but here also certain additional fact is given, and in this it is very important to remember that if word is used. Here, if there was no want of proper caution on the part of A, अगर इस केस में, हैचेट वाले में, अगर प्रॉपर केयर एंड कॉशन उसने एक्सरसाइज किया था, मतलब उसकी वांट नहीं थी, then his act is excusable and not an offense. So condition is given. If proper care and caution was there, then his act is excusable. So this is the defense of accident which is given under section 80. Very important case laws which are covered under section 80, that also we'll see. So section 80 हो गया. section 80 के ingredients समझ में आ गए. section 80 में जो illustration है वो समझ में आ गया. hatchet एक एग्जाम में आ गया था, ये पूरा स्टेटमेंट नहीं दिया था. इफ देर इज नो वांट ऑफ प्रॉपर केयर और कॉशन, और आंसर की में क्या आ गया, लोगों को लगा कि इलस्ट्रेशन जो सेक्शन में दिया है ये तो वही दिया हुआ है, हैचेट वाला. समटाइम्स दे कैन ऑल्सो ट्विस्ट द वर्ड्स, सो यू हैव टू बी अश्योर्ड, you have to read the illustration properly. They'll use the same illustration, they'll use the same illustration of the hatchet, but you have to keep in mind what is there in the bare act, what thing has been mentioned, whether it is exactly the same thing or is it is not exactly the same thing. अगर exactly same thing है तब तो आंसर वही होगा जो bare act में दिया है, लेकिन उसको अगर ट्विस्ट कर दिया है, उसको इनकम्प्लीट कर दिया है, कुछ सेंटेंस उसमें डिलीट कर दिया है, देन डेफिनेटली द आंसर माइट टर्न आउट टू बी डिफरेंट. इसीलिए जो है आंसर कीज कई बार होता है चैलेंज हो जाती हैं. ओके. So section 80 we understood. Similarly, another example is there. If A is at work with a hatchet at a place where children are playing, then the defense will not be available because his act was not done with proper care and caution. इसमें important case laws हैं. Jogeshwar versus Emperor. In Jogeshwar versus Emperor, what happened was that a person was fighting with another person, and what happened in this case was that a woman who was there, woman was carrying a baby, and the woman intervened between the fight of these persons, and the person who aimed a blow at the woman, it landed on the baby and he was killed. Now the question arises whether the person who has given this blow, should that person be given the defense of section 80 of accident and misfortune? So for that, I have already highlighted the important ingredients. And in that, proper care and caution, lawful act, lawful manner, lawful means is also there. So if there is a scuffle and a person is landing a blow on the other person, is it a lawful act which is done in lawful manner by lawful means? Is it done with proper care and caution? Definitely not. That is why section 80 was not available. The act of the accused was not protected by section 80 of the Indian Penal Code. Okay. जोगेश्वर वर्सेस एम्परर, ये भी याद रखिएगा. वुमेन जो है इसमें इंटरवीन कर देती हैं. वुमेन was carrying a baby. This is the case of Jogeshwar versus Emperor. Then Tunda versus Rex. Two friends were there, very fond of wrestling. They had agreed also. And by mistake, what happened was the other friend, while they were wrestling, he got injured. And also, death occurred. So in this case, it was a case of accident was available, the defense of accident. Okay. Then State versus Rangaswamy. Very important case. In this case, a person fired at the bush, believing he saw an object, he thought it was a hyena. एक जानवर उसे लगा कि बुश के पीछे जो है एक जानवर है, उसको देख के हंटिंग में he had fired. It turned out to be a man. State versus Rangaswamy. अब डिपेंड करता है कि फैक्ट्स एंड सर्कमस्टांसेस क्या थे, कोर्ट के सामने क्या फैक्ट एंड सर्कमस्टांसेस आए, उस बेसिस पे कोर्ट जो है डिसीजन लेती है. तो इस केस में इट वाज स्टेटेड दैट द मैन हैड एक्सरसाइज्ड ऑल ड्यू केयर एंड कॉशन, all proper care and caution was exercised by that person depending upon the fact of the case, therefore the defense was made available. So case law के नाम ही याद रखने हैं. R versus Swindle and Orborio, ये भी केस है. R versus Swindle and Orborio. ये देखिए, two car drivers were there and they started racing with each other, and in due course they hit a pedestrian who died. It was not a case of accident. It was not exercised with proper care and caution. The defense was not available. R versus Swindle and Orborio. Osborne. Sukhdev versus Delhi State. In this case, Supreme Court said that the Section 80 exempts the doer of an innocent or lawful act in an innocent or lawful manner from any unforeseen circumstance, accident or misfortune which is there. If either of these elements is missing, the defense of Section 80 will not be given. Okay. So that's all for today. We'll continue tomorrow and we'll finish off general exceptions. General exception khatam kar denge. Okay. We have to move fast in this since it's a crash course. We cannot delve too much in detail, though still I'm trying. Gradually we'll gain pace also. Okay. Initially we are slow, gradually we'll gain pace. So if you have any doubt, Raksha, offense will be no. बताओ रक्षा और महिमा, डू यू हैव एनी डाउट? चलो, so fairly easy. You must have studied Indian Penal Code many a times, but since we have the course, our old students are there. हाँ रक्षा, unmute yourself.
Good morning, sir.
Yes, yes, Raksha.
Sir, actually, if my act is not lawful in itself, suppose I'm trying to shoot someone, and in that I'm targeting A person, and in place of A, B come all of sudden, then obviously no defense will be given.
You are asking question on which topic?
Sir, I'm asking simply question like, if suppose without any excuse I'm trying to shoot person A,
Hmm.
and in between person B comes while I was shooting person A, then I don't think so any defense will be given to such person who's
Yes,
shooting.
you can mute yourself. I'll answer. So, in this case, the liability will be decided keeping in view what was your original intention. Because if your original intention was wrong, then by virtue of transfer of malice, if any person had intervened in between, the same intention will be imputed as you had caused the death of any person who had intervened in between. तो वहां तो ये डिपेंड नहीं करता है, ट्रांसफर ऑफ मैलिस का डॉक्ट्रिन लग जाएगा. लेकिन अगर इस केस में अगर ओरिजिनल इंटेंशन, even original intention was justified, then also we will see if any person had intervened due to external circumstance, then original intention will be seen. If that is justified, then definitely the doctrine of transfer of malice will not be imputed. सेक्शन 80 की बात तो जहां पे है, तो सेक्शन 80 में देखा जाएगा फैक्ट्स क्या थे, whether proper care and caution was there, whether lawful act was there, whether it was done in lawful manner, whether done by lawful means. If any of the things is missing, section 80 will not be applicable. Okay. Okay, guys. Thank you. See you tomorrow.